Welcome to the ABCs of Starting and Managing Your Law Practice. This is a presentation of LOMAS, the Florida Bar's Law Office Management Assistance Service.
Hello, and welcome to the ABCs of Starting and Managing Your Law Firm. My name is Judith Equals, and I am the Director of the Florida Bar's Law Office Management Assistance Service, LOMAS. During this DVD, I will discuss with you not only the issues surrounding the startup of your new law practice, but also what tools you will need and where to find these resources and materials. LOMAS Practice Management Advisors will never soft pedal important facts critical to your startup plan. Many of the tools you will need are free, but certain other tools and reference materials you must have are not free. You must purchase them. LOMAS tries very hard to minimize these costs for you, but still you must have these tools. LOMAS Practice Management Advisors are not lawyers. We are former law firm administrators with hands-on direct experience in managing the business side of the law practice. And with that, let's get started with the ABCs of starting your law practice. Let's begin with an overview of your startup toolbox and the resources that are available to you. We're going to talk about where these resources are located. We're going to go through an overview of the LOMAS website, additional resources from the ABA, an overview of Florida Bar member benefits that can help you with your startup plan, and finally the role that the LOMAS Practice Management Advisors have to play in your startup. Next, we're going to go through step-by-step instructions. We're going to review law practice management resources available to you and where you can find them. We're going to go over your business plan, your choice of entity, governmental licensing and business registration, tax reporting issues. We will cover the startup checklist in detail. We will then talk about necessary business management skills that if you do not already have, you will need to acquire. We're going to discuss why lawyers and other professionals often do not have these business management skills. And finally, we're going to discuss how to build your own private collection of law practice management resource materials that are going to help you start up your practice and manage your practice properly. First, we're going to go through an overview of the LOMAS website. The LOMAS website is maintained by the LOMAS Practice Management Advisors. You should visit our website often, very often, because we do keep it up to date. It is the place for you to find the latest resources, tips, and information in law practice management. So let's take a look. In order for LOMAS PMAs to show you the resources available during this DVD, you're going to need access to the internet. So first I want you to go to floridabar.org/LOMAS. And you're going to be at the LOMAS homepage. And I'm going to show you some of the things that are available to you. First, we show you popular resources and what's new in LOMAS. What new educational resources we have, what kind of services we offer, and how to contact us. Next, we will show you news in the law practice management area and other articles from the legal marketplace, and our LOMAS materials and LOMAS publications. The next thing that we will show you on the LOMAS web pages is the online free LOMAS Administrative Forms Manual. There are over 100 forms in the manual on client communications, such as letters of representation, non-engagement letters, disengagement letters, sample conflict waivers. We have a financial management section that has a sample chart of accounts and other financial management forms, housekeeping forms, for you to use in starting up your practice. There is also a personnel section and much, much more. So please take a moment to look at the online forms manual. We also, of course, have the startup checklist, which is not only on our website, but is also part of the handouts with this DVD. And finally, at the bottom of the LOMAS homepage is a topical index of articles and resources in law practice management, starting with computer software training, moving on through disaster management, financial management, of course, records management, human resources, insurance, the role of the inventory attorney, marketing, and many, many other topics, and we try very hard to keep that up to date for you. Taking a closer look at the LOMAS Administrative Forms Handbook online, you can see that we've pretty much covered the forms you will need to start up and initially manage your practice. These forms are free. You can bookmark this as a favorite, or you can download all the forms at once. If you have any questions about these forms, you should be contacting LOMAS. As we move through the startup of your practice, it is very important for you to remember to look before you leap and call LOMAS. We expect you to call us or contact us, email us as often as you need to, so that you set up your law practice properly and not make mistakes, avoid the perils and pitfalls. There are additional resources from the ABA that are excellent, and of course the ABA's website is abanet.org. And to start off with the Smart Soloing Center, the ABA Center for Professionalism, the disaster management area of the website, the ABA bookstore. The ABA bookstore, just in the law practice management section, has over 300 publications, all at substantial discounts if you're for Florida Bar members, for you to go in and take a look at those materials. The ABA Law Practice Management section is a very active and lively section. It includes, of course, an e-journal and up-to-date news in the legal marketplace and technology news. The ABA has also begun an economic recovery resource center and has practice management tips, information on student loan repayment, and much, much more. Here is the main page of the ABA's Law Practice Management section. To get an idea, you should be visiting this with me and what they have to offer, and I've shown you here what you can expect to get from the ABA, which is quite a bit, but also how inexpensive it is to be a member, to take advantage of all the resources that they have. And if you are a new lawyer, it's free. Now that we've taken some time to look at the LOMAS pages on the Florida Bar's website and looked at the ABA's website for resources that are available, let's also now go back to the Florida Bar's website and let's look at the member benefits page. Member benefits is something you should be looking at at least once or twice a year. Our member benefits include services that will help you with your insurance portfolio. We now offer merchant card solutions to make it really trouble-free to accept credit cards for fee payments. There is free legal research through FastCase, and in 2009 we rolled out the Florida Bar Career Center. And finally, we have discounted products from both the Florida Bar and the ABA. So let's take a look now at our member benefits. The member benefits page, it's got an alphabetical listing at the top, everything from the ABA bookstore to United Parcel Service. And as you go down below, you will see all of the benefits in detail. Please take quite a few minutes, actually, to go through this and check out each and every one of the services available, because it'll include FLMIC for professional liability insurance. There's health insurance, life insurance, disability insurance, and much, much more. So now that we've looked at some of your online resources, now we're going to start talking about establishing your own law practice. So let's get started. The first thing that I need you to do is to open up, and it's in your handouts, or you can go online to the LOMAS website, and let's look at the startup checklist. You should have in front of you now the Florida Bar LOMAS's startup checklist. So let's take a look at the first First step in starting your practice is developing your business plan. You're going to draft a business plan. You're going to need a budget for pro forma, and you're going to review this business plan with either an accountant or someone who's either been through this process or has a business background. You really need to develop your business plan first. There are books available that you can purchase for your business plan, or you can go to the public library, and there are many fine books to show you step by step what you need for your business plan. I could put a sample of a business plan before you, but no two lawyers are alike, no two law practices are alike, and no two business plans are alike. A business plan is not a complicated document. It can be as few as 5 pages, usually not more than 15 pages, and it has fundamental factors that go into it, which we will go through. LOMAS strongly recommends that you purchase the How to Start and Build a Law Practice by Jay Foonberg. This is a good handbook to accompany this DVD, and LOMAS sells this book at a substantial discount. Part of your business plan is building your startup kit. No two law firms are alike. The needs of the lawyers starting up their practice vary widely. LOMAS has developed additional products for you. Some of them, you'll need them all. For some of you, you'll need them all. Others of you may need 1 or 2. And so that's why we have developed them individually so that you can build a customized startup kit that suits your needs. Some of these products are financial management for the non-financial professional, maintaining a trustworthy trust account, technology for the new law practice, marketing basics for the new law practice, building business in a down economy, lawyer as employer, and the LOMAS sample policy manual. What I mean by building your own startup kit is if you are truly going to start up as a solo practitioner, you may not need lawyer as employer as part of your startup kit because you will not have employees, whereas you very well may need the maintaining a trustworthy trust account. Please don't guess and don't blow through the business plan. The business plan is, not having one is leaving your future to chance. You need to take control of your destiny. You need to maintain an external focus. A business plan will help you maintain an external focus. Developing a business plan means that you've agreed to be managed. You've agreed to manage yourself. It forces you to develop an alertness to changes in the legal marketplace, economics, competition, marketing, trends, politics, technology, and changes in various industries. The components of a startup business plan basically do not change. They're not applicable to everyone. I've talked to a lawyer the other day, and where he is going to get clients is not part of his business plan. He's being given a block of clients by a retiring lawyer. So that part of his business plan is not applicable. Another lawyer calls our office and tells us that he is being given a virtually brand new technology system. So that part of his business plan he doesn't have to go through. But you must go through the steps. And the first one is why. What is your overall goal in starting up your practice? And that is also known as your mission statement. Why are you doing this? The objectives are the mileposts along the way to achieving your goals. What are the objectives and what are the challenges? Analysis of your resource and needs, and where is your plan weak and where is it strong? Oftentimes, many lawyers, this is the point where they will call a consultant or they will call LOMAS, and they will try to get that honest analysis of their resources, because that's often hard to put that down into writing. How will you get there? What kind of budgets do you need? What kind of staff, if any? You need to have that needs list as part of the business plan. And finally, an action plan. This is the chronology of how you will put things into place. And if you will look at your startup checklist, you will see that it's formatted so that it has a deadline column, It has a column if there's anyone to help you that you can assign tasks to. It also has a column for startup costs and recurring costs, so it can be the beginning of your pro forma budget within your business plan. The business plan is always evolving. This is not a one-time plan and then we do it and then we throw it in the drawer. It's constantly revisiting this as part of the budgeting process. What kind of law firm do you want to be? What type of clients are desired? What type of services do you want to offer now and in the future? What are your goals as to growth? Bearing in mind that sometimes getting small or staying small is also an aspect of growth. How large is the firm going to be? What type of services can it offer? What locations can it be in? How will it be governed? What will be the structure? How will it be financed? How will we staff it? And how will we promote our image? How will we market the firm? This is all part of the business plan. If you're not comfortable creating your own business plan or you're not comfortable with some of the resources that are there in the public library, a very inexpensive book available from the ABA bookstore is Creating a Business Plan, and it's less than $25. Plus you are eligible for Florida Bar member discounts. And if you are a member of the Law Practice Management section, you get an additional discount. So this is a great little book on walking you through your business plan. If you have your business plan under control, next we can go to our choice of entity. In order to discuss your choice of entity, you should have your startup checklist with you now. Also, we're going to go back to the LOMAS website, and once you're at the LOMAS website, we're going to click on Starting Your Own Practice Resources. Going along with you as we do this, and here you will see all the resources we have put together for starting your own practice. In addition, this article it was put together by Frank Rodriguez, President of Corporate Creations. Frank is an attorney with an LLM in taxation, and you should be pausing this video in a few moments to read this article, to go through the tax consequences and the corporate structure of each of the choices in addition to sole proprietorship. So we're going to look at a professional association. We're going to look at a PL, which is the professional's version of an LLC. We're going to look at an LLP, and then finally discuss sole proprietorship. So take a moment to go through this article, and then we will come back to this DVD. Now that you've read which entity should I choose, you also need to refresh yourself with Florida Statute Chapters 620 and 621 on partnerships and LLCs and PAs. Once you have chosen your entity, we can move on to the next phase of starting your practice. Governmental registration requirements for startup businesses. You've decided what type of entity you are going to be. You have your startup checklist beside you, and you are connected to the internet. So now it's time to visit sunbiz.org, and there you will find the forms. They are free, necessary to file your incorporation. If you do not know the specialized language that comes at the beginning of your charter that discusses the purpose of your corporation, know that everyone else's charter is public record, and you can go and look at as many other law firm charters as you care to, and you can pick up that standard language and insert it into your own charter. Next, you're going to need occupational licenses. If you are leaving a law firm, you own your occupational license. It doesn't matter who has paid for it. The occupational license is yours. Most of the counties here in Florida and most of the municipalities require an occupational license, so check with the tax collector's office in your locale to see what the requirements are for the occupational license. There is a stiff fine for not having one. You need an occupational license for every lawyer in the firm, and if the firm name does not include the names of the living lawyers within the firm, for instance, if you are the Immigration Law Center, then the firm itself will also need an occupational license. If the firm's name, for example, is Smith & Jones PA, and Smith & Jones are both alive, then you don't need an additional occupational license for the firm. If you are planning to set up a virtual office, and so that your only physical office will be in your home, you still are required to have an occupational license, and in fact may be denied one because you are going to operate a home office. You may be required to visit the Office of Planning and Zoning in your locale and request an application for a variance. The wording that the government is looking for is that you will not be seeing members of the public in your home, and of course you should not be. So usually at that point they will grant you the variance and you can get an occupational license. It's always a good idea to have a post office box in addition to your home office, but I'll be getting into that a little later. To continue on with business registration and tax requirements, the next thing to do is to go to myflorida.com, and there is a link for new businesses and the registration requirements. The link is here in your handouts, myflorida.com/taxonomy/business. These requirements include, for law firms, registration with the Department of Revenue so that you can pay your unemployment taxes, and with the Florida Department of Financial Services so that you can register for unemployment compensation insurance, and go to the Division of Workers' Compensation at the Department of Financial Services website to see if you qualify for an exemption to workers' compensation insurance. Next, you will go to the IRS, www.irs.gov, and you will request a tax ID number, federal employer tax ID number. There is also a link at the IRS website that you can see here in your handouts, irs.gov/businesses/small/index.html, and that is the Small Business and Self-Employed Tax Center, and they have a wonderful guide there for new businesses. Next, I'm going to talk just briefly about technology tools. As I said at the beginning of this DVD, the ABCs of Starting and Managing Your Law Practice is a guide to the resources available that are both free and those that are not free. If you do not feel well grounded in technology management, then I suggest that you purchase the LOMAS Technology DVD on starting a technology plan for a new law practice. Most people utilize less than 20% of the capability of the software programs that they already own, and they skimp on the training. Having said that, lawyers are the second largest users of technology in this country as an industry, and it can run or eat up 6 to 15% of your gross revenues. Technology management is important, and it changes. Technology is introduced at such a rapid pace that we really strongly recommend that you read at least one legal marketplace technology e-journal every month, like Law Technology News or Tech Republic, and also view the LOMAS Technology DVD. And now we're going to go back to your startup checklist and go through it step by step. You should all have your startup checklist in front of you now. As you can see, that the way that I have formatted the startup checklist, it asks you for an opening day. I've categorized the steps and we've described the steps. Next is your deadline date and the date by which each of these tasks must be completed. The person responsible, if other than yourself, is the action a one-time startup cost or a recurring cost, and what will be, if any, the estimated annual cost so you can get started on your budget. As you can see, the first category is your business plan. And we recommend that you develop a business plan outline and you acquire the tools necessary. If you feel that you need the help, you can always contact LOMAS also. Creating a business plan is a very good handbook for this purpose. We also recommend that you purchase, new or used, the ABA book, How to Start and Build Your Law Practice by Jay Foonberg. Your entity setup means that you need to review Florida Statute Chapter 620 and 621, read the Frank Rodriguez article on which entity should I choose, and you should have a relationship with an accountant so that you can further discuss the tax consequences of each entity. You will obtain a tax ID number at the irs.gov. You will visit sunbiz.org to file your incorporation papers, unless you're going to be a sole proprietor. If you choose sole proprietor status, there are still tax reporting obligations that are discussed at the irs.gov. New firms of more than one lawyer also need a shareholder or partnership agreement, bylaws, and a buy-sell agreement. Samples of these forms are available free online in the LOMAS Administrative Forms Manual. We discussed your occupational licenses, and I've put it as a separate item on the startup checklist because it's an important item, because the penalties and embarrassment quotient are severe if you do not have your occupational licenses. You will register with the Department of Revenue and also with the Department of Financial Services. Next, let's discuss the location of your law office. Will you be virtual? Will you have a traditional office? Will you be both? You need to decide. This is because it's going to affect your finances, and you need to decide whether, logistically this is possible for you. Regardless of what type of office you choose to have, acquire a post office box. Go rent a post office box. You live in Florida. This is good disaster management anyway. If you have a home office, you do not want to be receiving law practice mail at your home address. It's not altogether safe. But also, if you are away or you're traveling or you go to another jurisdiction for a hearing, you want a safe receptacle for your mail, and that's a post office box. You may also want to set up an account at the Postal Service, USPS.com, for your mailing requirements. It's not always necessary for a small law firm or a sole practitioner to rent a postage meter. Typically, a stamps.com or USPS.com postage account is sufficient. Next, we're going to talk about financial management and banking. If you do not feel well grounded in financial management, bookkeeping, basic accounting, or those aspects of running a law practice, we urge you to obtain and view Financial Management for the Non-Financial Professional from LOMAS, and this will go in detail into the types of statements you'll be running, setting up your books, opening a chart of accounts, what these reports mean, how to use them, how to interpret them, why they're important, and why you must pay attention to them. It'll also go over bank reconciliation statements and other aspects of financial management in the law firm. Also, one of the fundamental parts of your personal law practice management library is results-oriented financial management for lawyers. All of the products that I am suggesting to you from the ABA are available to you at a steep discount because you are a Florida Bar member by using your Florida Bar member discount code of PAB6EFLB, and this discount code is placed in several places in the handouts on this DVD. The financial management of your law practice always begins with the structure, the skeleton, and that is your chart of accounts. Many accounting firms and certain software packages will give you a chart of accounts that's not practicable for a law firm. LOMAS has developed a chart of accounts for a small law firm, and it's available free online on our Administrative Forms Manual. You can use that chart of accounts with any accounting software package that you should later purchase. You'll be choosing an accounting and billing software package. Unless you have less than 50 transactions a month, you're going to need some accounting software, and we'll discuss that a little later on. Before you do that, you will need to set up your bank accounts. You've set up your entity, you've obtained your tax ID number and your occupational license. You now have the documentation necessary to select a bank and open an operating and trust account. Trust accounts in Florida, you're required to have an IOTA account, Interest on Trust Accounts program, through the Florida Bar Foundation. If you are going to be holding client money that is nominal, short-term, or must be kept liquid. If you are not comfortable with the trust accounting rules under the Florida Bar, then we strongly urge that you study Chapter 5 of the Rules Regulating the Florida Bar and also obtain and view the LOMAS video, Maintaining a Trustworthy Trust Account. Many lawyers who begin their new practice have not managed a trust account before, and sometimes it's been a few years since they've actually looked at the trust accounting rules. Now is the time to study those rules and memorize them. We're going to have to prepare a budget. Part of your startup plan, part of the business plan, is the pro forma budget. The budget is 4 parts, and we're going to talk about that in our startup slides a little later. If you need a line of credit to start up your law practice, you need a business plan. This is what the bank is looking for. The bank wants to know, where are you going to get clients? How will you market the firm? What will your startup expenses be? What will your compensation be? They want to see a plan of action before they are willing to extend a line of credit. Find out how your bank approves loans. Is it done by computer, or is there a physical loan committee that you can sit down and meet with and go over your business plan? This is also very important. Moving down the startup checklist, we've gone past setting up our entity, choosing our location, and fundamental tasks in financial management. Now let's look at setting up our technology. You need to draft a technology plan. You need to have a plan of action there also. LOMAS has a startup technology video, but it's also important to network with other lawyers to obtain local recommendations for a technology support person, because you can't do this by yourself, nor is it the highest and best use of your time. You need to discuss and define what kind of hardware you need. No two firms are alike. What types of printers, scanners, PCs, fax machines, telephone systems, what do you need? Because you don't want to overbuy, but you also don't want to undershoot that either. Email LOMAS for up-to-date discussions on the types of software that is available, office management software that's available to lawyers. We try very hard to keep abreast of changes in the industry and with these companies. You need to be very clear and decide how you will back up your system, whether you will use a backup tape, whether you're going to use a flash drive, whether you're going to back up over the internet, and be faithful to that backup plan. Because if you lose your data, there are stiff ethical obligations to protecting your client and business data, especially after the recent disasters in the last few years. You need to decide on a telephone system. Will you use a voice over internet protocol system? Will you use a service such as Skype? Will you use traditional telephones, or perhaps a mobile phone, your smartphone? And those kinds of choices are important, so you need to look at your client base and see how they expect to get a hold of you. And before you make a decision on what type of telephone system, you should contact LOMAS to discuss that. Telephone systems are discussed in detail on the LOMAS Technology DVD. Next on the startup checklist is practice management, the most important of which is your calendar and task management, and whether you'll be using a paper-based system or whether or not you'll be using software. Again, our technology DVD discusses this in detail, but it is part of the startup checklist. We're also going to go over it a little later on additional slides that I'm going to cover with you. Your client intake and representation forms, they're already devised for you. They've been developed in the LOMAS Administrative Forms Manual, which is online. A client interview and initial consultation checklist is also in our Administrative Forms Manual. You'll need to decide what types of fees and retainers you'll be accepting. And again, we'll go over this material in detail a little later. You'll need to set up an e-filing account with the courts. And if you have not viewed the free DVD on the new Rule 2.420 on electronic filing in Florida courts, you can access that under the CLE tab on the Florida Bar's website. You'll need to develop a list of practice-specific forms that you'll need for your practice area. There are vendors that offer these forms, such as ProDoc, but also you can develop your own forms using software such as HotDocs. Again, contact LOMAS for a discussion of up-to-date software, and we do strongly urge that you know what forms you're going to need and where you're going to find those practice-specific forms, and LOMAS is there to help you do that. Know that you can register for free legal research through the Florida Bar's Member Benefits page with FastCase. Also, the LOMAS page has a link to virtual law libraries around the country, and we try to keep that also up to date. Next, we're going to go look at marketing and advertising as part of your startup. Advertising is the last resort of marketing. Having said that, certain practice areas must advertise. The budget in a startup law practice for marketing and advertising, if you're not doing personal injury, is between 2 and 5% of your gross revenues. If you are doing personal injury or related areas to personal injury, it could take up as much as 15% of your gross revenue, so you have to be very careful in designing your marketing and advertising budget. LOMAS has developed a specialty DVD that goes into marketing in depth for small law practices. We also recommend that you buy, as part of your law practice management resource library, Marketing for Lawyers, which is an ABA publication I'll discuss later on during this DVD. So we need to develop the marketing budget. We need to look at what kind of advertising are we going to do, and know that advertising must be pre-approved by the Florida Bar's Ethics and Advertising Department. If you go to the Florida Bar's website and click on the Ethics tab at the top of the page, it will take you to the Ethics Department, and there you will see the link to the informational packets and also the advertising handbook. It is critical that you review this material before you embark on expending any money on advertising or marketing. You'll need to decide what kind of a website you're going to have and what kind of budget. You can spend very little on a website, you can spend a fortune on a website. So look at other lawyers' websites and decide, call LOMAS and decide what you can afford to have and what best suits your practice area. Will you have client newsletters, firm brochures? Network with other lawyers in your area and see what the client base in your locale expects to see from the lawyers in your practice area. If you plan to share space with someone else, and you're allowed to share space with another lawyer or with another business, as long as you follow the guidelines in the ethics opinions. All the ethics opinions are organized not only by their number, but also in a subject index, and one of those subjects is offices and office sharing. If you are planning to share office space, take a look at those ethics opinions and pay particular attention to signage and security. If you are sharing space, you must show that there's more than one business in the building. Look to your signage and also provide security over your space so that no one but you can enter the confines of your space, so that you can preserve client confidentiality over your files and other data in your office. As you get close to your opening day, you'll need to develop mailing lists to vendors, to people who are interested in where you are going to locate. These types of mailing lists are not considered advertising as long as they fall under the guidelines of a tombstone ad, which is basically an announcement that you have opened a law practice, where you are located, and how you can be contacted. Tombstone ads do not have to be approved by the Ethics and Advertising Department. One of the last items on the startup checklist is equipment and systems, the nuts and bolts of the back office of your law practice. Will you need a digital photocopier? Most people do. What kind of filing supplies? Even if you go completely paperless, you will always have some paper. So what type of filing supplies and file cabinets will you need? You'll need to start a master file list of your work. Develop incoming and outgoing mail procedures and other fundamental law office procedures for your office. LOMAS has a sample table of contents for a procedures manual, and it is in your handouts. You can use this as a basis to create your own manual of procedures. And even a solo practitioner needs a handbook of law office procedures because you might hire a temp or bring in temporary help. And when you do that, it's usually because you're very busy, and so you don't have time to stop and explain to them how you want your law practice to run. So it's good at the start to develop these procedures and document them. Part of the back office setup is maintenance and janitorial. This is important not only for cleanliness, but also for office security and client confidentiality. How will the office be cleaned? Who will be cleaning it? Who will be maintaining the office? Who will be handling repairs and maintenance? And it's an important item on your startup checklist. You're going to need supplies. The biggest mistake that any small business owner makes, including lawyers and other professionals, is to run off to the local big box supply store and run up and down the aisles and fill up their carts. It's a waste of money. Develop an inventory. Develop a supply inventory. Visit another lawyer's office to start to create your inventory, or start from scratch and create that inventory and then ask for a discount. When you have a big supply order, you're going to go to the office supplier and you're going to ask for a discount, and usually you will get one. Also look at online suppliers such as quill.com that offer steep discounts and have huge distribution centers around the country. Stick to your standard supply inventory. If you're spending more than $1,000 a head per year on office supplies, something's wrong. Something's wrong. Also, in your chart of accounts, we have a tendency to use the office supply account as a dump-all for expenses that should be itemized. Computer maintenance expenses belong under technology accounts. Reproduction, paper and toner and the like, those expenses belong under a family, a grouping of reproduction and copying accounts. And office supplies should be only for office supplies. Next on the startup checklist is what kind of furnitures and furniture, fixtures, equipment, and artwork are you going to need for your office, and determine what kind of startup budget that you have. Know that you can rent furniture, you can look for used furniture, you can even go to thrift shops and find suitable startup furniture. I've met plenty of lawyers who have repainted desks and repainted file cabinets that they found in thrift stores. I know they go to scratch and dent sales. Some people that have great budgets can afford to go out and buy new furniture, but it is an expense. So we need to look at what kind of artwork can we afford. Do we need special flooring? What kind of chairs? And I will tell you, please, you're going to be spending a lot of time in your chair. This is an area that you should not skimp. Get the very best chair that you can possibly afford for your desk. conference room furniture, reception room furniture, will you need that? Do you need a desk for a secretary or other lawyers, credenzas? Look at the window treatments and also look at security issues in the office and office safety. Look for areas of torn carpet that need to be replaced. Really do a good thorough walkthrough and create a punch list of what needs to be done to your space so that it'll be ready on opening day, whether or not you need to paint, whether or not all the lights are working, etc. Determine where built-ins might suffice. Built-ins are very, very inexpensive. Usually a local carpenter can do a built-in credenza for much less money than actually buying a freestanding piece of furniture. If you are going to have a virtual office in your home, this still means you need a comfortable, ergonomically suitable place to do your work, whether that's an extra bedroom. I once met an attorney who did trust and estates work, and he and his wife decided that their dining room was never used. So with a little drywall and a new door and some built-ins, he built a very nice office in the family's dining room that was completely closed off from the rest of the house, and it saved him and his family a great deal of money by having this virtual office. He, in fact, went and visited clients rather than have them come to his office. Another important part of the startup checklist as you move through this is to contact LOMAS. Our email address is on our website, and you should contact us as many times as you need to. As I've said before, and I will say again, no two lawyers are alike, no two law firms are alike, so no two startups are going to be alike, and your needs are somewhat unique to you and your location and your practice area, your budget. The final item on the startup checklist is personnel. If you are not going to be a sole proprietor, if you are starting up your law practice with staff, then you really should view the LOMAS video, the DVD, Lawyer as Employer, and you should also get yourself a copy of the LOMAS Sample Policy Manual. Oftentimes during a startup, we say, well, we're going to do that later, and then with the first mistakes that's committed is a labor and employment violation. Oftentimes, no one ever complains about a labor and employment violation until you have to lay somebody off or until they leave your employment. If you're not a labor and employment specialist, you need, as a business owner, to be up to date with your obligations under the federal and Florida labor and employment laws. And you also need a good, simple policy manual so that you are setting limits and boundaries for your staff. If you are hiring staff that have experience in another law practice, that doesn't necessarily mean that they're bringing good habits to your law office. You will also need to develop personnel files for them and enroll them as new employees into the new practice. They're going to need W-4s, they're going to need I-9 forms from the Immigration and Naturalization Service. There are payroll taxes to set up, and your accountant can help you with that. But again, we strongly urge that you view the LOMAS DVD, Lawyer as Employer. And the last item on the startup checklist is what else? LOMAS cannot second guess you. I'm sure you will have other specific items that you can add to this document that you will need to investigate to set up your law practice. Now we're going to return to more step-by-step instructions. One of the most important tools in your toolbox of starting your own law practice is having the proper business management skills. Most professionals do not have these skills. Some do. Some have business management degrees. Some lawyers are even CPAs. But most professionals, lawyers, doctors, etc., they graduate after so many years of college and do not have a foundation in business management. And this does not mean they cannot acquire it, but if you're going to start your own law firm and be the owner of a small business, you must understand what skills you need to hone and how to find help to nail these critical business management skills. In the legal marketplace, any survey, there are so many surveys done out there, but picking the important ones from the ABA, National Association of Law Placement Professionals, the American Corporate Council, and so many others, the number one reason why a lawyer is not promoted is lack of business management skills. By the time a lawyer is being looked at for promotion, it's already assumed that they're a good lawyer. But now the question is can they manage a fundamental aspect of the business operation or actually manage the entire practice? If you have hopes of being a successful law firm owner or going into partnership with another lawyer and watching your firm grow over the years, this will not happen if you do not have the proper practice management skills, business management skills. We've seen this not only in the private law firm but also in government. We've seen it in corporations. A law office is a law office, and there are certain things that are common to all of them. And in order to manage a professional office, certain skills are fundamental. Poorly trained attorneys contribute to the turnover rate in a law practice. And in fact, the turnover rate in this country of associate attorneys is over 30% and has been for the last 30 years. And the reason why is lack of management skills. If an associate, or for that matter a paralegal or any other staff person, doesn't feel they're being managed properly, ultimately they are going to leave. Unless you find yourself saddled with an employee who thrives in chaos. And anyone who thrives in chaos is not a producer. You do not want your office to look like this. What kind of management skills are necessary to run a law practice? First and foremost, financial management skills. Do you know how to read financial reports? Do you actually know the difference between a debit and a credit? That's not funny. It's an honest question because many lawyers come out of law school not really knowing. That doesn't mean it cannot be learned. So the basics of financial management, how to read financial reports, how to do a month-end reconciliation, and how to prepare a bank reconciliation or read and interpret that work when it is prepared by someone else. Next are project management and decision-making skills. Very few of us are inherently organized, are organized as a part of our character. Anyone who is ever taking a personality test can see that being uber organized is actually in a minority of the people. That doesn't mean you can't learn to become organized and learn to manage big projects. So you need this skill not only to manage your law practice, but also to manage your client work. Human resources and supervision skills, again, many people are not comfortable managing others, and it's something they have to learn how to do. There are resources out there to help you. The public library has many good books on supervising others. The ABA bookstore also has specialty books on supervising others. And finally, the LOMAS DVD, Lawyer as Employer, will get you started in the nuts and bolts of developing a system for managing your personnel. The next skill is records information management and managing technology. These require organizational skills above and beyond what most people normally have. It doesn't mean that you can't learn them. But when it comes to managing legal information, law firm information, client information, there are best practices that have already been developed, and they are out there for the taking. We strongly urge that lawyers acquire the book, The Lawyer's Guide to Records Management, and we'll talk about that at the end of this DVD. And finally, how to develop workable systems. Can you develop a process? Can you look and see how a task, a function needs to be handled in your office and develop the steps necessary so that it works efficiently and also safely, So can we develop processes? And again, this is something that you can learn to do if you're not comfortable doing it. However, there are also best practices have been developed and are available from LOMAS and from the ABA and are also in our sample policy manual. The management challenges in the law office include marketing. This is because many people do not inherently have marketing skills. In fact, according to many personality tests, it's 2 to 10% of the public generally has any inherent marketing skills. It's something we have to learn, or as one famous marketing consultant said, not everyone is a rainmaker, and we don't want a law firm full of rainmakers because who would get the work done? But everybody can learn to be a mist maker, and sometimes mist making is enough. And I very much believe that statement. Next is practice management disciplines, making sure we've defined what services we're going to offer and not step outside of our areas of expertise and possibly commit an error. Are we specialized? Do we know what our specialization is? And do we know what specializations we may need to acquire in the future? Technology management, again. Succession planning and retirement is a rather new challenge in the law office and is the result of what the ABA has called the senior tsunami. And this is this huge tidal wave of aging baby boomers that are still working in the law office. They still plan to work well into their 60s and 70s, so that now that we have 4 generations in the law practice, and sometimes this causes a bit of a communication problem and adds, I think, some extra spice to our human resources management, but it is a challenge. For law firms, not just a law office, but a private law firm, we have to add 2 more challenges, and that is pricing legal services and profits allocation. Pricing of legal services has always perplexed lawyers. I think it always will, but determining what is the competitive price that still allows us a reasonable profit in our particular legal marketplace. And I will be discussing setting of fees later in this DVD. And finally, profits allocation. Profits allocation needs to be looked at as the amount of money that you are compensated that makes this endeavor worth doing. And that is actually part of the budgeting process. It's also part of the planning process and also part of records information management. We put all 3 of these together to get a good idea on profits allocation. Do we have the data to determine where we are making the most amount of money from our work? Is it work that we enjoy? And is it work we can get more of? So all of these aspects go into profits allocation. Again, one of the best handbooks you can get on planning and financial management is Results-Oriented Financial Management for Lawyers from the ABA. All of the foregoing really comes out to a question of balance. Owning your own law firm is a juggling act of sorts in keeping the proper amount of leverage going. In other words, having the work that you want with the people that you need and like to do the work for an amount of money that makes it worth doing. And this requires planning, and this also requires having proper business management skills. You did not wake up this morning and say, today is a good day to be grieved. The road to you-know-where is paved with good intentions. No one sets out to be grieved or be sued for malpractice. Lawyers work hard for their clients. It's important that you achieve balance in your life and your career. This takes planning and knowing how to plan. You need to learn how to prevent risky actions and unhappy clients. In order to do that, you need to have a good set of reference material that you can study and refer to at any given time. You also need to remember to call the bar when you have a problem. Look before you leap. Contact LOMAS, call the ethics hotline. We're there for you. Also SCOPE, which is your silent partner, which is a service of volunteer lawyers who can help you with legal questions. As you can see from this slide, this is what can happen when a lawyer does not have a time budget, does not know how to manage their time or how much time they have available for work and for their home life and for career development. I might joke about time management seminars, but for any business owner, not just lawyers, but any business owner who's not attended a time management seminar is doing themselves a big disservice. A time management seminar workshop is a good investment. It's going to help you learn how to manage and track deadlines, how to keep time records, which I will cover later, the importance of lawyers keeping time records, how to manage your records and information, how to manage your docket and your files, and how to develop and use a conflict of interest checking system for more than just checking for actual conflicts. The conflict system will do much more than that. And most importantly, a time management seminar, because it's going to teach you how to budget your time, it'll help you learn to say no, because you will know how much work you can put on your plate. When a LOMAS practice management advisor walks into a law firm and we see, sometimes we feel, signs of a management breakdown, and we know that the breakdown is caused from poor management skills or lack of management or management best practices that are not being enforced in the law firm. There's chronic stress or chaos, there's no budgeting process, no planning process, no training manuals. Poor records management, filing backlogs, client complaints have become part of the landscape. There are calendar and task errors. It's just, you can feel the seething chaos in an office that's not being managed properly. There are 7 business processes in a law practice. The 7 business processes have not changed in over 4 decades. I don't think they are going to change anytime soon. And if you know how a law office should be organized, then this will help you get started the right way. First is production. That's organizing to get the work in and get the work out. Next is marketing. That's planning to keep the work you have now and acquire the work you want in the future. Communications is a process that has its tentacles in all the other processes. How well do we manage risk? Do we avoid disaster? How well do we train others? Do we evaluate their performance? All of these fall under the communications process. Personnel management is an important function, not only because it's with managing our people, which is our most important asset, but personnel costs can be 60 to 70% of our gross revenues. People need to be properly managed. Next is systems and technology management, the tools that we use to get our work done. Financial management, and the bottom line, that's organizing the flow of the money in and out of the law practice. And finally, the 7th process is management, owner management. Only owner management can control important aspects of the law practice, such as client relations, risk avoidance, and most importantly, vision and direction, and morale. So let's take a look at the first process, production, organizing to get the work in and organizing to get the work out. We're going to take a look at a few of these key business processes. We're going to go over these because a breakdown in any of these could bring you to a grievance or a malpractice lawsuit. So let's start with the intake process. The intake process is the Rosetta Stone of representation. The intake process means correctly interviewing the client to determine what it is they want you to do, what is their sense of urgency, their ability to pay, whether or not their expectations are realistic. After you finish the interview process, then you need to intake certain information so that you can do the work and protect the law firm. The LOMAS Online Administrative Forms Manual provides you with a sample intake form and also a sample client interview sheet for you to use as a basis to develop your own. The intake form should include information, not just the name and the address, but what about, alternative addresses. You should verify identity with a driver's license so that you can be sure that you're actually talking to the person the client purports to be. How are you going to reach them? How they expect you to provide status reports on the work. Is it going to be by email? Is it going to be by telephone? Is it going to be by letter? You outline the scope of the work again. You document the agreement on the fee in the fee agreement. I'm going to talk about setting fees and fee agreements a little later in this. You always do a representation letter with the fee agreement. The fee agreement talks about how you will be paid. The letter of representation goes over the scope of the work and your approach to the work and what the client needs to do in order for you to do the work. And the client and you should sign both the fee agreement and the letter of representation. The intake form also pulls enough information, gathers enough information from the client so that you can do a proper conflict of interest check. Also, there should be a space somewhere on the intake form for the client to write out what it is in their own words they want you to do. And although you may already know this, the reason for that portion on the form is so that you can determine whether or not your client is literate, or at least at what level they're communicating with you. Lawyers are wordsmiths and they're highly educated, and often they make the mistake of communicating at a level that is over the heads of their clients. Next, the conflict of interest checking system. Many lawyers have told me, I don't need a conflict of interest checking system. I don't have conflicts of interest in my work. Every practice area has some exposure to a conflict of interest, just some more so than others. You can use case management software to do conflict checking. Many financial management software packages have a conflict checking mode, but you can also use Excel to set up a conflict database that would include the name of the client, their address, the type of work, opposing counsel, related parties, relatives, and any other information that might be the basis of a conflict. A conflict of interest checking system can also be used to provide you with information that may touch your life. That, gee, if I had known this information, I would have never taken this work. So you gather that as well. And please be aware that a perceived conflict must be explained to the client's satisfaction. And we also do have in our forms manual a conflict waiver form, but we urge you to use that with great care. There is an ABA book in the bookstore at the ABA website, several of them actually, on conflict of interest if you need more help developing a conflict of interest system. Opening the file. How we open the file and how we track the file. Many times work begins before we have documented that we own the file, that we've opened it, and we've taken on the work, and that can be very dangerous. So opening the file and giving it a unique name and or number, I do recommend using an alphanumeric naming system for file opening. Many of the key factors in file opening, again, is covered in the Lawyer's Guide to Records Management. So properly opening your file and having a good file list so that you never lose track of a file, no file falls through the cracks. Telephone call management. The #1 complaint by clients all the time, anywhere, any state, is I can't get a hold of my lawyer. Documenting your telephone calls. Most case management systems have a telephone call module or you can use telephone message books. You can use an Excel database, but you must track telephone calls coming into the office and telephone calls going out of the office. And by the way, that also includes visitors. Visitor management. It is very important to track the visitors that come to your office. There's been many instances of lawyers meeting with a prospective client and then deciding not to take the representation, declining representation. The lawyer then did not do a non-engagement letter. In other words, we met, we talked, but I cannot represent you. They did not document that, and the client leaves the office with the impression that they've retained the lawyer. It's a very sad circumstance and should be avoided at all costs. Calendar and task management. LOMAS practice management advisors often go into law firms and find there are many calendar applications, even in a small law firm. There actually is no firm-wide calendar. Everyone's keeping their own type of calendar, whatever suits them, and that cannot be allowed. We have to have one calendar system in the office. We have to have an office-wide calendar. If something were to happen to any key individual in the office, we must be able to get to the calendaring information and tasks or to-dos, deadlines, immediately. File closing and archiving. Familiarize yourself with Florida Bar Ethics Opinion 88-11 reconsidered, and all our ethics opinions again are on the Florida Bar's website under the Ethics tab. In Florida, many are unaware that the lawyer owns the file. This is not the same from state to state. Different bars take different positions, but in Florida, with certain protections, of course, for the client, the lawyer owns the file, so how long will you keep a file? What steps will you take when you prepare a file before it's closed, and how will you store it? A sample records retention and destruction schedule is available on the LOMAS website for your use, but only you can decide how long you need to keep files, because a lot of that decision is driven by your practice area. Do you do routine personal injury, or do you do trust and estate planning? It really depends how long. The last process on this list is records information management. How well do we manage our data and protect it? Do we have a system in place? We have safeguards in place to back up our data or protect our paper files from breaches in confidentiality, from wind, from fire, from hurricanes, from floods, from theft, break-ins, and other perils. Again, the Lawyer's Guide to Records Management is an excellent, excellent handbook that every lawyer should have. The next process is planning and marketing. I could go on for days about marketing the law practice, but that is why LOMAS developed a separate DVD for marketing the small law firm. And if you need help developing a marketing plan, I recommend that you acquire that DVD. Marketing for a law practice has not changed since the 1960s, not much. The fundamental aspects of a marketing plan have stayed the same. It's a plan on how to keep the work you have. Somebody else might want that work. Even if you plan to not do that work in the near future, you need to protect the work you have. You need to create a plan on how to get the work you want in the future. Where is that work? How do you meet the people that can give you that work? What skills do you have to do the work? It's all part of a long-range plan. The marketing plan, of course, is part of the strategic plan. The quality of your operations affect your marketing efforts. Everything from the front door of your office to reception to the quality of your letters, even if your bills are attractive, your invoices. Every aspect of your law office operations affects your marketing efforts. The reason why we don't market is, as I mentioned previously, because for many, many people it's not in their nature, but you can learn how to market, how to create a marketing plan, and it's a matter of once you have the education on how to market yourself, then getting out there and executing your plan. If you don't feel comfortable with marketing, I strongly recommend 2 tools, which is the LOMAS DVD on marketing your small law firm and the Lawyer's Guide to Marketing from the ABA bookstore. The key components of a planning effort are the direction and buy-in. Are you serious about executing the plan? If you're not going to be serious, don't waste the time. Many people feel, well, if I join 10 clubs, I'm marketing. That's not marketing. How to build the trust relationships, how to properly network, how to budget your time for marketing, and how to run the proper reports to get your return on investment. In other words, I spent X amount of dollars on marketing. How much new work did I get as a result of those marketing efforts? Can I analyze my efforts? Do I track my marketing time? Do I benchmark it against the marketing efforts of my competition? How do I staff it? Is it somebody else besides me? Can they be involved in our marketing effort? And how am I going to fund it? An important budgeting aspect. These are the key components of a planning effort. The next process in the 7 business processes is communication, often called greasing the organization's wheels. I often ask lawyers when I talk to them about the communication function in their law office, I say, how well does the law firm communicate the partnership entry criteria? What is the criteria necessary to become a partner? Do any of the associates even know what it is? If the associates, I ask them, do you know what that criteria is? Do you know if you want to be a partner at this firm? I ask, does the firm even need any new partners? Is this being communicated? The necessity to define, document, and distribute critical information on risk management and disaster preparedness so that the firm can survive. 60% of businesses that go through a disaster do not open back up. That's it. That finishes them off. They close the doors. But after Hurricane Katrina, lawyers have been put under a special onus to protect their data and be able to come back up and operate after a disaster. There are ethics opinions now at the state level and at the ABA, the Florida Bar and the ABA, discussing lawyers' obligation to preserve their data. Next, do we have policies? Do we have policies in place even if we have just one employee? We have policies in place on how you want your firm to operate. These policies, these processes, these procedures, what I mean is, what is our policy on flex time? What is our policy on social media? What is our policy on talking to the press? An important process would be, how do I get a check? How do I get a trust check? How do I get an operating check? What are the procedures? Those are the steps in completing this process. LOMAS has sample policy manual. We also have, for free, we have a table of contents to develop a procedures handbook. But the most important thing to remember about creating your procedures handbook is it's the way you want your law firm to operate. Do we cover orientation, training, and mentoring? I know this is not very important for a lot of the solo practitioners in the audience, but even with one employee, how do we train them? Many times people are brought in, especially if they have law firm experience, and we assume that they know how to do something, how to do work the way we do it, and they don't. They know how to do the work in the place they used to work. And the place they used to work may have been a chaotic, mismanaged office. So unless you communicate through orientation and proper training, they're going to bring bad habits to your law office because they're going to be a little bit afraid to ask you over and over again how to do something, because isn't that what you hired them to do? why don't they know how to do this? But in fact, something as simple as the incoming mail process can be very different from office to office. So again, document this and make it part of orientation. LOMAS has a sample orientation checklist. It's in your handouts. You go through it and you know, did we cover operating account? Did we cover billing? Did we cover how to get a trust check? Did we cover how we prepare documents? How about how we save documents? How we retrieve documents, our work day, our work week, how we handle leave and absences, and how we cross-train. The requirement that people learn aspects of other people's jobs so that when we have an absence, the entire office doesn't come to a screeching halt. The culture of the office needs to be defined and communicated. And I've visited many law firms over the years, and some law firms I walk in and everyone is in blue jeans and polo shirts. I walk into another office and everyone is in business suits. What is the culture of the office? Is it laid back? Is it very formal? This usually reflects the client base, but it's a good idea to define your culture. What your attitude is towards client relations, towards communicating with clients, toward behavior in the office towards each other. Are we a hard driving office, fast-paced? Are we more laid back? What is our culture? And finally, looking at client relations so that everyone understands how we treat clients. This is critically important because how we interact with clients can be very different depending on our practice area. Certain types of clients involve a lot more hand-holding than other types of clients, and it's your job as the owner of the law firm to define how you want clients handled and treated. So with that, I'm going to spend some time now on client relation skills as part of the communications function. 3 important skills required to interact successfully with clients: listening skills. Listening skills sometimes have to be taught. You may not have good listening skills. Try them out. Try them out with somebody. Ask people what they think of your listening skills and acquire special training if you feel you need additional work with listening skills. This can be obtained from Chambers of Commerce, skillpath.com, certain organizations such as Toastmasters. Speaking and listening skills, very important. Learning the client's business environment. That is just a business management skill that is absolutely critical. Not learning everything you can about the client's business environment so that you can understand what it is that they do, what kind of pressures they're under, and most importantly, long-term would be how viable the client's business is. The client expects their lawyer to understand their business and environment, and that often means getting in your car and going to the client's workplace instead of always requiring the client to come to your office. Learning how to build productive trust relationships with clients. The client wants that relationship. The most important lawyer, according to client surveys, is the lawyer who manages all of the client's needs, even if the lawyer themselves doesn't actually do all of that work. But the client wants to know that they can go to this one lawyer and discuss any and all of their business needs. And then that lawyer will tell them who is going to handle the problem for them, and that he or she is going to supervise that work, being a client manager. Delivery skills, work product delivery skills are very important in client relations. The lawyer assists the clients in clarifying goals, which means oftentimes setting limits and boundaries. If the client says, you know, I will sue these people and I don't care what it takes and I don't care how long it takes, that's an unrealistic expectation. Those goals are not realistic. We have to set limits and boundaries. We have to have a case budget. We have to document what the client will be satisfied with, what outcome will they be satisfied with, defining the scope of the work in the terms that the client will understand. Again, I've often done readability statistics on lawyers' work product. This usually makes many lawyers giggle, laugh, because I'll run the readability statistics on their documents, and it'll show that they're writing at grade level 22, 21, grade level 23, that many years past the 12th grade. In client communications, writing at grade level 22, by the way, is just fine if you're writing to another lawyer or if you're writing for something that's getting filed into court. But if you're writing a case status report, you cannot write at that grade level. You have to bring that back down to the high school or junior high school level in order to communicate with many, many clients. Even someone with an advanced degree in the sciences may not have your English skills. So communicating with the client on a level they can understand, efficiently delivering the legal service requested. Is there a value added that you can put on the service that your competition cannot? But before that, figuring out what is quality legal service in the client's mind, avoiding selling the client the Rolls Royce when what they want is a Chevy. And if you price it as a Rolls Royce, they're going to go see another lawyer. You know, what type of a will, how complicated should that will be if that's what they're coming to you to discuss? What's the work product? How complicated is it? Selling sizzle and no steaks, in other words, promising the moon and the stars and not being able to deliver on that. Providing timely and accurate status reports of important information to the client. There are two kinds of ways to do status reports to clients. There are event-driven reporting and calendar-driven reporting. Most lawyers are very good at event-driven reporting. Something significant happens in the case, we write the client a letter, we call the client. But what if nothing significant happens in the case? What if the case is going to go on for a long time and it's been laying dormant? And that's to be expected. And the client is calling, what's going on with my case? What's going on with my case? You want to use both systems, event-driven and calendar-driven. Use your automated calendar, Outlook, or the calendar in your case management system to put in a recurring reminder so that the same day of every month you pull your client list and you review it and make sure that every client has been contacted with the status of their matter. In the old days, before there were computers in the law office, we actually used a card file to do this. We used a tickler file with the days of the month. And every day we would pull out reminder cards. Now we have calendaring software that makes this so easy. There's no reason for anyone to let status reports fall through the cracks. It's often said that everybody you will ever meet is a potential client, and perhaps that's true and perhaps not. But if this statement is only partly true, how do you build your client relation skills? One way to do this, and it's free, is to study the battery of free articles dealing directly with client relation skills that are available on the Law Practice Today e-journal archives at the American Bar Association's website, www.abanet.org. You can also email LOMAS, and we can provide you with marketing articles that we have in our archives as well. And always remember, client relation skills is an important aspect of risk management and marketing. Another way to build your client relation skills is to attend bar-sponsored seminars in the general practice solo and small firm section. Starting and managing your small firm marketing effort is a CLE DVD and is part of the set of products that LOMAS has developed to help bar members build and manage their law practices. There are other workshops available that are not specifically designed for lawyers, but are designed for professionals and are of good quality. These are available through your local chambers of commerce, through universities and colleges. LOMAS does have to tell you to beware of hiring a marketing coach. Do your due diligence. Marketing coaches and consultants can be a godsend and be very helpful in helping you manage your marketing effort. But if you're not comfortable with your marketing plan or skills, the coach can help you. But caveat emptor, let the buyer beware. You must do your own due diligence to be certain that the marketing coach or consultant has direct, hands-on experience successfully marketing a law firm. Get references, agree in writing on what the fee for the consultation will be, and be sure the consultant is well grounded in the Florida Bar's advertising and marketing rules. The next process in the 7 business processes in a law office, number 4 is personnel. This is about organizing the people. As I mentioned previously, human resources is 60 to 70% of a law firm's gross revenues. So what kind of skills do we need? It's too easy to fall into the box of, I need a paralegal, I need a legal assistant, I need a file clerk. Forget those titles and define what kind of skills do you need to fill what kind of positions. It could be that you need one full-time person, and that one full-time person could be 3 part-time people that you could then cross-train. There are many places to find well-trained personnel who don't make as much money as experienced law office staff, but have similar skills, such as banks, physician offices, hospitals, police departments, depending on the type of task that you need done. How much experience do you need your people to have? In other words, are you good at training someone else? If you don't have the patience to train someone else, it's not in your nature, you're going to have to hire somebody with experience. But you're still going to have to document your processes as to how you want your office to run. What kind of skills, what kind of positions, what kind of experience, and how much experience. How many people do you need? This can be a trap when you read staffing surveys. It'll say it's common for a ratio of 3 lawyers to 1 legal assistant. That's a staffing ratio, but that doesn't necessarily have anything to do with deployment. I would never put 3 lawyers on 1 legal assistant without backup, because if the legal assistant is not there, then I have 3 lawyers with no help at all that day. So it's important that if you're working within a group to learn some team building and make teams and be sure to cross-train. And it's important that you demand of your employees that they accept this fact. Change is not an exception to the job, it's part of the job. And so they must learn to cross-train. Orientation, skills, and process training is your responsibility. Also, the cross-training. Cross-training to a level, but don't Peter principle people, asking them to do more than they are capable of doing, but define and make it policy of the tasks in the office that everyone, or mostly everyone, needs to know how to do. For example, everyone should know how to work the telephone system. Everyone. Everyone should know how to operate all the equipment, even if it's not their primary job. Performance measurements. You can go to any office supply store and buy a performance evaluation form. It's usually a grading scale. It's very generic. It's typically what I see when I see these at use in law firms is, rank this person from 1 to 5 on different criteria. And of course, the lawyer will rank the employee 555 because they don't want to face them in the morning and rank them anything less than perfect, because this person is an integral part of how they get their work done. The performance measurement and evaluation should first of all tie directly to a job description. Do we have a job description? And then second, it should be a narrative of a few important factors like how well does this employee, set an example, how well does this employee treat clients, how well does this employee get their work done on time? And then you write how well they do that and what part you have to play in improving their performance so that you can have an adult, calm discourse with them on performance improvement. If you're not comfortable with personnel management, as I've mentioned previously, LOMAS has a DVD. It's a 3-hour DVD on personnel management and labor and employment law compliance called Lawyer is Employer. And it's a very good product to give you a good grounding in managing others and to keep the firm out of trouble. Also rewards. How will you give rewards? This is where you can really get out of the box. Rather than a raise, which will also raise the basis of your overtime, perhaps you will give bonuses. Maybe you will give small performance bonuses throughout the year. I know one law firm down in the Keys who has to recruit staff out of Miami. They give their employees gas cards so that this is an expense to the firm, but it doesn't affect payroll taxes and it doesn't affect overtime. So they give their employees gas cards. Another law firm I know gives employees their birthday off. It's a paid day off is their birthday. What can you do to structure a reward system that's meaningful to you and also is good for the competition? And then finally, you're responsible for morale. You're the owner of the firm, and only you can control morale and control the morale of your subordinates. It's up to you to keep morale at an acceptable level. And that means you have to be very careful about who you hire. Because if you hire people that don't work well with others or that enjoy creating chaos, these are people that will destroy the morale in your office. When you're interviewing people, you need to look for people that are going to enhance morale and not drag morale down. In fact, LOMAS practice management advisors would tell you that they will take the above average employee with the great morale versus the superior skilled employee with poor morale any day. Because morale is an important productivity aspect to the work environment, and you must protect the high morale within your firm. Hiring and firing of personnel in Florida, we are an at-will state, and you do not want your actions to violate your at-will protection. You want to know how to interview. LOMAS has interview tips, and we've included these in your handouts. You need to know how to check references and keep up to date with your labor laws. How to terminate employment. So I'm going to tell you a story, a sad story about one solo practitioner who called us on a Friday afternoon right before quitting time, and he asked for one of us to drive down to his office immediately. And we told him that that simply was not possible and to tell us what had happened to him. And he said that all the data on his computer system, this is a solo with one employee, all the data on his computer system was gone, had been erased, there was nothing there. And I asked him how that could happen. He said he had fired his secretary that day and that she had a copy of all the material, but she had taken it with her. And he asked me what I should do. And I told him that he should call her and apologize and say whatever it took to get her back into the office, and that he should strongly consider calling the police at that point because that was a crime. But it goes to show you, go to a safe place when you're terminating personnel. Nobody likes to terminate anybody, but if you have to terminate someone, go to a safe place. Always protect the firm's data. Use a checklist, a termination checklist. All of these personnel issues and more are covered on the LOMAS Lawyer is Employer CLE DVD. If you are starting up your law practice with employees, we strongly recommend that you view that video. LOMAS has 3 cardinal rules in supervising others. It is arrogant to believe that you can supervise someone when you do not know what it is that they do. Everyone must agree to be managed, and everyone must agree on how they will work. Too often we see startup law firms that are really confederations of solo practitioners, people that throw themselves together without a plan, without documentation, and without rules, and the firm doesn't last. The firm, in fact, ends up demerging or dissolving. There can be no Lone Rangers, and no one's work is so unique that there's no set of rules or policies governing the production of the work and protecting the work and the confidentiality of the clients. You may be very well grounded in technology management, and so you may not need the LOMAS Technology DVD that we offer, but it's important that we mention here as part of your startup plan is to have a technology plan, find local tech support with impeccable references, find out where you're going to get your software, who is going to support your software, what does your competition use and what do your clients use. Do not skimp on training. Training can cost sometimes as much or more than the technology that you actually buy, but it is not the highest and best use of your time to plow through an instruction manual that you may not even understand. So part of your technology costs is the training. The determination of whether you should lease or purchase the technology is one that you should consult with an accountant. Tax laws do change. Is it better to lease this year or next year, or should you purchase this year? What amounts can you write off? What has to be put on an amortization schedule? Who is going to manage the actual system, and who is going to be responsible for its security is another question. And stay current. Technology changes rapidly. Read a legal tech periodical every month. View the LOMAS Technology DVD if you don't feel comfortable managing technology. The 6th process is financial management, organizing and accounting for the flow of the money. What you must know about financial management includes internal financial controls, managing an insurance portfolio. We're going to cover timekeeping, billing, and collections. Reports, what kind of reports do you need? Productivity reports, profitability reporting, trust accounting, and we're going to cover budgeting. If you're not sure about your financial management skills, you feel you need additional training, the LOMAS DVD, Financial Management for the Non-Financial Professional, has been developed for you. LOMAS Practice Management Advisors are hoping that you will look at all of the products that we have put together for starting your practice and that you will build your own custom toolbox. The first subject we're going to cover in financial management is internal controls. Except for solo practitioners, of course, no one person in a law firm should have total control over any critical function. And in fact, for solo practitioners, I recommend that you leverage some aspect of internal controls with your accountant or a trusted advisor or a trusted friend, because you still have exposure to theft and fraud if you don't have another pair of eyes looking over the operations of the law firm. So examples of internal controls would be the person who writes the check does not sign the check, the person who posts the deposit doesn't physically make the bank deposit. These are important controls. Locking up all of our banking supplies, shredding voided checks, who can sign on the operating and trust account. If you're not comfortable with some of these internal controls, contact LOMAS and we can discuss your particular situation. Again, we've mentioned this before, but it bears mentioning again. The reference book in the ABA bookstore, Results-Oriented Financial Management for Lawyers, has more detail, and we'll talk about that book at the end of this presentation. Look before you leap and contact LOMAS if you are concerned about internal controls. We had a lawyer call our office one afternoon, and she said that the Broward County Sheriffs had contacted her and that some people were out on State Road 7 selling her trust account checks for $1 a piece. Somehow they had gotten into her office, we don't know how, but she was in a large office building and they had stolen a supply of her trust account checks. It's something you cannot put off till later, making sure good internal controls. An important aspect of the financial management function is your insurance portfolio. The insurance portfolio can run 10 to 20% of your gross revenues and needs to be managed carefully. So the first and most important part of your insurance portfolio is your professional liability insurance. I go visit many law firms throughout the year, and I ask them if they told the truth on their professional liability insurance application. Of course, they say, well, of course we did, but in fact, they've inadvertently have a fib on the application because they haven't truly done their due diligence on every question. One of the most important ones there is, do you have an office-wide calendar? So, in fact, do we? And another piece of low-hanging fruit on that application to commit an error is the question, are any of the lawyers an officer or director of a corporation? And we answer no, and in fact, perhaps one of the lawyers is an officer or director on their homeowners association board, which is a corporation, and so now they have risked voiding coverage if they should have a problem because of the answer they put on their application. Professional liability insurance is not required in Florida. That's not the same in every state, but in Florida, a lawyer does not have to carry professional liability insurance coverage unless it's required by a lawyer referral service, or a title company would in fact require professional liability insurance coverage. The longer you practice, typically the more expensive your professional liability insurance is. It's important to find a good independent agent that has experience in acquiring PLI for lawyers, or contact FLMIC, Florida Lawyers Mutual Insurance Company, through your Florida Bar Member Benefits portal. The next piece of insurance in your portfolio is your general liability insurance. This protects your furniture, your fixtures, your equipment, artwork. It also covers liability within your office should someone hurt themselves. A client should say fall down or trip or hurt themselves in your office. Two valuable and important riders in a general liability insurance package is valuable papers and data coverage. Should you have a disaster and you would need to recover the information on your computer system that's been damaged, or paper files that have been damaged, you need to have plenty of coverage, because there are companies that specialize in recovering this data and they are expensive. The other rider is fraud and theft coverage. Should you have a theft in your office, if someone does hack in or steal money out of your trust account or your operating account, do you have insurance coverage to cover that theft? And like any other type of insurance, if you don't have inventories, you can't prove ownership after a loss. The insurance company is looking to see inventories with receipts. We recommend taking a video film of the contents of your office, having an inventory, and also having the receipts to back up that inventory. A depreciation schedule is not an inventory. You really need to have a current, up-to-date inventory of your furniture, fixtures, equipment, and artwork and accessories. Finally, employee benefits. This is not necessarily important coverage for most startups, but if the startup is a large startup, meaning several lawyers and several staff people, you may need this kind of coverage because you are offering group benefits. If there is a mistake made in the enrollment of a lawyer or a staff person, a mistake has been made in enrolling them in group coverage, the consequences on the end of that can be very, very severe if it's the retirement plan or the health insurance policy and the like. The financial reporting function includes the monthly preparation of fundamental documents such as your income statement or the report of profit and loss, your balance sheet, your bank account reconciliation report, the statement of trust balances, an aged accounts receivable and work in process report, and that report should be run by client and also by responsible lawyer, and your budget. And we're going to cover these in subsequent slides. The bank account reconciliation report in Florida, your trust account must be reconciled monthly. Not all states require that. The Florida Bar Rules, Chapter 5, do require monthly reconciliation of your trust account. Fiduciary accounting is the concept of the agent reporting to the principal. And that is what a trust account is. It is a fiduciary account. Lawyers in Florida do not have escrow accounts, even if they use their trust account for property closings. It's still called a trust account. That is in the rules. An IOTA trust account is one that has been enrolled in the Interest on Trust Accounts program through the Florida Bar Foundation. An IOTA account is used only for trust accounts that are holding client money that is nominal, short-term, or must be kept liquid. If you are holding a significant amount of money for a client that is not short-term and it's not nominal and doesn't necessarily need to be held liquid at all times, then you would separately invest that in a separate interest-bearing trust account for the benefit of that specific client. So when you're using an IOTA account, you would use the tax ID of the Florida Bar Foundation. When you're using a separate interest-bearing trust account, you would use the tax ID of the client or related third party who's entitled to the interest or who owns the money. The IOTA forms are on the Florida Bar LOMAS web pages. The forms to establish your IOTA account, there are 4 of them, and they are in PDF format for you to download. If you are holding client money at any time, it must be in a trust account. Familiarize yourself with Chapter 5 of the rules regulating the Florida Bar. And if you're not comfortable with managing your trust account, then you should add to your toolbox and view Maintaining a Trustworthy Trust Account, the LOMAS DVD covering trust accounts in detail. You must supervise your banker, your accountant, and your bookkeeper. We have met many lawyers, the LOMAS Practice Management Advisors have met many lawyers who got in trouble with their trust account because their banker, their accountant, or their bookkeeper let them down. You have to supervise them. Often your banker and your accountant have never read the trust accounting rules regulating our trust accounts, or the bookkeeper has not received adequate training. When practicable, valuable client property should be held in a safe deposit box. You may safeguard this client property in your office, except for securities. Securities, according to the rules, must be held in a safe deposit box. LOMAS recommends that you obtain a safe deposit box as part of your startup plan. The rules governing client money also govern client property. So the same rules that govern the money govern the property. Rules regulating the Florida Bar 4-1.15 on safekeeping property advises the lawyer to follow the trust accounting rules when holding client property. Next, we're going to discuss budgeting and forecasting. Budgeting is critically important planning tool for the law firm budgeting and case budgeting, both. Nailing your budgeting skills is going to help you both with managing your law practice and managing your clients. Budgeting is a fundamental component of the strategic plan, the marketing plan, and your business plan. Without time records, lawyers are budgeting in a vacuum. I cannot stress this strongly enough, and I will talk about timekeeping a little later. You know, what is a budget? First of all, many people think it's something that's etched in stone. It's a guide. It's a guide. It's evolving. We try not to make changes to a budget, but if we have a material change in operations, we may have to make a big change to our budget. The important thing to remember about law firm budgets is that they're comprised of 4 parts. Always 4 parts. We always start with a revenue budget. The revenue budget is how much of your time is going to be invested in the law practice to generate revenue. And I'm going to show you an example of an individual revenue budget shortly. The next piece is the expense budget. What will our expenses be? And we take the expense budget and the revenue budget and we put it over a cash flow budget. In other words, when do we expect to receive the revenue? When do we expect to spend money on operating expenses? And we try to match the two up into a rhythm so that when we're paying for big ticket items in months where we expect to get the most revenue, this keeps you from having to draw down on your line of credit. It doesn't start off perfectly at first, but as you continue the budgeting process and stick to it, it gets better. The budget starts with revenue generation, not with expenses, so let's look at a revenue budget. Here's an example. I take the lawyer, and no two lawyers are alike, and we look at how many hours per week can you devote to the law practice totally, a total time investment picture. I use 46 weeks. You'll see in your handouts 46 weeks. And the reason for that is because we're going to preserve the concept of the healthy lawyer, of a balance between your work and your personal life. And so we are assuming a 2-week vacation. We're assuming that you will close on the major holidays. And we're going to put a contingency in there of 2 weeks for things that happen that we don't expect. You know, expect the unexpected. So in this case, we're looking at a lawyer who says that he or she is going to work 55 hours per week on the law practice. So at 46 weeks, that's going to give us 2,530 hours. You would think that we would start with the work on files, on client files first, but that's actually not the standard approach. Instead, we're going to look at hours on marketing. How many hours do we have to market? So now you see why that marketing plan is so important. How many hours on marketing? And that is a schedule that we attach to the budget. And what will those activities be? Next, we look at practice management and supervision. Managing the practice that you cannot bill for. How many hours will that be? How many hours on law office management, other tasks? So managing your practice, the client work, and supervising your employees, and next doing management tasks such as reconciliation reports and reviewing financial reports. And for solo practitioners, it often means doing their own bookkeeping. And last, our pro bono hours. And we deduct that from our gross hours, and we see in this instance we have 1,900 hours to work on client files. So from there, we need to look at how much do we charge per hour, or if we use flat billing or contingency billing, we now know how many hours we have, and so we now know what our internal hourly rate is for planning purposes. You must have time records in order to do budgeting. Why we keep time records? The last reason is to get paid. There are many ways you can get paid. You can do contingency, you can do flat fee, non-refundable. We keep time records first and foremost for the ethical obligation to have a record of the work. Next is for profitability and productivity reporting. If a lawyer works solely on contingency, how can they demonstrate whether or not they're profitable if they don't know how many hours it took to do the work? Also, if a lawyer is supervising another lawyer or supervising a paralegal, how do they know how productive that their subordinate lawyer or subordinate paralegal is if they don't have hours reports to look at? It's critical to the success of your startup law firm to get in the habit of timekeeping. And remember, if you do not do hourly billing, send out hourly bills, internal time records do not have to be beautiful. They just have to be accurate. And lastly, we use time records to get paid, or if you're working contingency, flat fee, or non-refundable, you need those time records if your work is challenged, because it will burn up a lot of your potential billable time to recreate the record of the work after the fact. And as to billing, the bill is part of marketing as well as getting paid. Is the bill beautiful? Does the bill tell the story of the work that was done? And ask the client how they expect to be billed. The best form of the bill is the one that gets paid. Many clients have bumped bills back to lawyers and saying this is not the billing format that we require. The lawyer never asked them how the client expected to be billed. Using your billing software to track the results of non-billable activities. You track all of your time. You can set up non-billable codes in your billing software. You can even do this on a manual basis so that every hour that you spend on the practice, whether it's billable or not, is recorded so that later you can pull the reports necessary to analyze how you're doing. An expense budget is always formatted against the firm's chart of accounts. We take the chart of accounts where we're posting expenses and revenues, and we build our expense budget against it so we have some history to look at. How organized and relevant is the chart of accounts is very important. So make sure that you use the LOMAS small firm chart of accounts so that your reports are more meaningful to you. In other words, marketing expenses are under marketing, reproduction expenses are under reproduction. I often go into law firms, and when the lawyers started up, they were handed off a generic chart of accounts for any service business, a barber, dentist, florist, lawyer, doctor, and it's very generic. And so I asked the lawyer, how much money are you spending on marketing? And I get kind of the doe in the headlights look, because the lawyer realizes that the expenses for marketing are all over the place. They've been coded to business entertainment, business development, letterhead, business cards, website, and all of these expenses, when all of those expense categories should have been bundled and reported as sub-accounts under marketing to make it more meaningful for the lawyer to read later. The income statement, the profit and loss statement, should be reported with columns for both actual revenue and expenses and a comparison against the budget. So for instance, your profit and loss statement is actual expenses for the month in one column, your actual expense year to date, the annual budget allocation for that line item, and then lastly, the variance or percentage of whether or not you're over or under your expectations. The cash flow budget. When do you expect to actually pay for this item or to earn your revenue? LOMAS practice management advisors visit many law firms, and we look at their budget or look at their financial reporting, and they've actually have a cash flow budget, perhaps sometimes prepared by an outside accountant. But the lawyer and the accountant, or even if there's no accountant, the lawyers have not talked to each other, and so they've just taken their expenses and divided them by 12, which is a waste of time. The cash flow budget, we actually break out all our invoices, and for a startup, this is the best place is at the beginning. When do we expect to pay for our operating expenses, and when do we expect to earn our revenue? If we find that we've got some big ticket items in a month where we don't expect to get a lot of revenue, contact the vendor and move that expense to a month where you earn more revenue. This is going to decrease your chances of drawing down on your line of credit, and never borrow money on your line of credit to pay owner compensation. As I mentioned earlier, we're going to discuss setting fees. LOMAS often receives calls from lawyers on asking us how to set a fee or how much should they charge, and we really can't answer how much the lawyer should charge. Lawyers' fees in Florida vary drastically from Miami to the Panhandle and all points in between. When setting the fee, it's important to analyze whether the revenue is going to satisfy operating expenses. The temptation to charge too little just to get started or to take any kind of work that comes in the door, and we actually end up digging a hole. The amount of the fee has to satisfy operating expenses, also known as the burn rate, and satisfy a reasonable amount for the lawyer's compensation and taking the risk of owning the business, the profit. So you have to answer these questions. Is the work worth doing? Is this work worth doing? Are you competent to do the work? Are you working efficiently so that your practice area is productive and reasonably profitable to you and affordable to the client? There should be a fee agreement for every client matter. The Florida Bar does not require written fee agreements except for contingency work. However, if there is a dispute to the fee, as to the fee between you and the client, the bar cannot help you if there is not a written fee agreement. The fee must be established and agreed to by both parties, and the fee must be reasonable. Every new client matter, even repeat matters from the same client, deserve a new written fee agreement, thoroughly documented, that outlines what the amount of the fee will be and how it will be paid. The fee agreement is then accompanied by a letter of representation. These are two different documents. The letter of representation is the lawyer's opportunity to clearly define the scope of the representation again, to describe what the lawyer can do and cannot do, will do and won't do, and the client and the lawyer sign both of these documents. And samples of both of these documents, several samples, are in the LOMAS Online Administrative Forms Handbook. Rules regulating the Florida Bar, Chapter 4, Rule 4-1.5. Rule 4-1.5 addresses all the factors in setting fees, limits and boundaries involved, and any lawyer who's going to start and own their law practice needs to become very familiar and really study this rule. It sets out limitations on contingency fees. Also, there are some ethics opinions that you must study to learn more about setting fees, and the most important one is 93-2, which addresses the types of retainers and how they are handled. There are true retainers, fixed retainers, flat retainers, and non-refundable retainers, but you have to know what's the difference between the four and which ones to use and how to prevent an excessive fee situation. So a true retainer is a retainer that is paid to reserve the right to hire you. It's also called a conflict retainer. The client does not have specific work for you to do at that time, but they want to reserve the right to hire you if a problem comes up. True retainers are considered earned the moment they're put in your hand. They are never placed in the trust account. They go directly to operating. A fixed fee, flat fee, or non-refundable fee are also treated the same. They are considered earned by the IRS the moment they're put in your hand, and they go directly to the operating account because earned fees may never be placed in the trust account. Learn about handling retainers in Ethics Opinion 93-2. And lastly, ABA Ethics Opinion 93-379, which is in your handouts, is an important watershed opinion concerning how lawyers may charge for costs. Lawyers may never make a profit on their costs. Direct cost advance are passed through to the client at whatever they cost the lawyer. A hard cost advance, such as writing a check for a court reporter or paying for express mail service. Soft costs, such as telephone calls, postage, photocopies, those must be charged at what it costs the lawyer to deliver those services. We cannot mark those up. Lawyers may not charge blanket administrative fees for costs, a blanket file setup fee, or charge a percentage of the fee itself as costs. Costs must be itemized and tracked. In Rule 4-1.5 are the guidelines for reasonableness, and there are many of them, as you can see in your handouts. The guidelines for reasonableness include the time and resources required, novelty, complexity, and skill required. Precludes the lawyer from accepting other work. If accepting this work will keep you from accepting other work, that plays a factor in setting the fee. The customary fee charged in your local area plays a factor. The significance of the matter, the responsibility involved, and some lawyers call this bet the farm work. This is very important to the client, and it's going to involve a lot of time and effort on your part. That affects the fee. The urgency and the time limitations imposed by the client. If it's an emergency situation that is going to preclude you from taking other work, or requires that you put other work aside where you can, that affects the fee. The solidity of the relationship with the client, what the client expects you to charge them, and what they're willing to pay, what they value the service as, the expertise level and reputation of the lawyers involved, and if a fixed fee, whether the client's ability to pay rests significantly on the outcome. It is important to mention here that the lawyer may never invest in the outcome of the work. Other considerations involve interest on unpaid fees. Lawyers in Florida may charge interest on unpaid fees, but only on the principal. Florida statutes prohibits charging interest on interest. Unit billing and task-based billing, there's some excellent books in the ABA bookstore on using task-based billing, but Florida case law and the Florida Bar v. Richardson and Rule 4-1.5 does not prohibit it, but you have to be sure that your method for unit billing or task-based billing does not result in an excessive fee. The fee must always be reasonable. And finally, there are these considerations in setting the fee. Will there be a conflict of interest? Did you check for conflicts of interest? If there is a conflict, it must be communicated to the client. Rule 4-1.7. A conflict waiver may be executed by the client as long as they understand the basis and why they are waiving the conflict. The question to ask is, would an ordinarily prudent lawyer seek this conflict waiver? Charging for paralegal time, we refer to in re the estate of Platt. The paralegal time must be under the supervision of the lawyer. The question to be asked is, but for the non-lawyer's special training, would the work have been performed by a lawyer or by a clerical staff? If the answer to the question is the work would have been performed by a lawyer, then it is billable, it's paralegal time. This is a very important factor in staying competitive with fee setting and bringing value to your clients. If you're pushing work down to the appropriate level, that can save the client money. Fee agreement should include a statement that there is no guarantee as to the outcome of the matter, the power of attorney to execute documents when appropriate and prudent, provisions for a retaining lien, these should be discussed with the clients, the method for resolving disputes with the fee with the client, and the client must be able to understand the fee agreement. Lawyers, as I mentioned previously, often write over the heads of their clients. It is absolutely critical that your fee agreement is a document that the client understands. A contingency fee agreement must contain the statement of client rights, specificity in the levels of contingency as to a pre-suit settlement, a settlement during the initial stages of the suit, pre-trial settlement, and if the lawyer is taking the case on appeal. Expenses to be deducted, those have to be covered in the contingency fee agreement. If the expenses will be deducted from the recovery and whether they're deducted before or after computing the lawyer's fee. Sample contingency fee agreements are in the LOMAS Administrative Forms Manual as well as the Statement of Client Rights, and you can obtain a Spanish version of these documents from the Florida Bar's Public Information Office. If there's going to be a division of fees in a contingency fee case, the division of fees must be proportional to the service rendered amongst the lawyers involved. The division terms have to be fully disclosed to all the lawyers and all the clients, and all the lawyers have to assume joint responsibility for the work. The client has to have full knowledge of what the split is going to be and who will be working on the matter. Absent court approval, division between the referring attorney and the working attorney is limited to 25% and 75% respectively. LOMAS recommends that you provide monthly billings or monthly billing summaries regardless of the fee arrangement. This is part of client status reporting. If the fee is flat or it's a contingency, time records give the client a monthly summary of what you did. If monthly billing, the bill should be a clear narrative of the work performed on the matter for the accounting period just ended. Who worked on the matter? What work did they do? Why were costs expended? If it's a final billing, show any unbilled work in process or accounts receivable that has been written down. And a good, clean, well-written bill is also good marketing. You should never surprise the client. Always avoid surprising the client by doing a monthly summary. The final process in the 7 business processes in a law office is the management. This is owner management, not management that you might hire, but you yourself who own the firm. Owner management pulls all of these processes together so that you have a shared vision, shared goals, you've agreed to be managed, you have structure and governance documents to guide you, you have a budget, you have policies in place, you're maintaining an external focus, and you've nailed the numbers. You have a plan, you're implementing your plan, you can define your culture, you have a handle on employee relations, conflict avoidance, client relations, and risk avoidance or risk management. A few words about compensation systems. They drive behavior. You get what you reward. It's a very simple saying, and it's very true. If your compensation system, when you're starting up your law firm and you're deciding how the lawyers will be paid, if we default to a labor-driven plan, an eat what you kill plan, it's going to hurt your growth efforts later. Compensation systems should reward marketing and mentoring. Compensation systems should reward handing off work to the best person for the job. And in fact, the most compensable time a lawyer spends in a law firm is keeping other people busy. It's called being a multiplier. The compensation system should include rewards for keeping clients happy. We don't hoard work. We don't step outside of our specialty. There aren't that many compensation systems in a law firm, and in fact, there's a very good book. It's on the ABA bookstore, Compensation Plans for Law Firms, if you think that your toolbox needs this book. But basically, the compensation systems in a law practice are the lockstep. The failing of the lockstep is the partner retires but doesn't tell anybody. It's an old joke. The lockstep system, we still use it, for example, incoming new associates or anybody in the same employment classification. We don't know how they're going to turn out, so we have a beginning salary. That's an aspect of lockstep. The eat what you kill compensation system is actually a mangled version of the formula system, which was rolled out as far back as 1948 by the law firm of Hale and Dorr. But when we mangle it and turn it into an eat what you kill, a computer runs the law firm. And it does. It tempts people to hoard work, and it kills efforts to specialize. The formula system involves strong intake control. So yeah, we still look at our computer to see what those numbers tell us, but we also have strong intake control, so management is deciding who the best person is to do the work, and the person who brought the work to the firm gets an origination credit. And finally, the objective-subjective compensation system. A little over 60% of the law firms in America are now using this system, and it's based, we use the computer, it's based on numbers and subjective factors that we use through an evaluation form or a written narrative, such as How well has the lawyer improved their management skills? Do they keep clients happy? Do they cross-sell the services of the firm and other subjective factors such as that? Do they supervise other people well? Can they mentor? Are they good for morale? And other firm-first behavior. This DVD on starting and managing your law practice is going to end with how to build your law practice management library. You're going to see in your handouts on this DVD, several places on the Florida Bar's website, but especially the ABA bookstore, Florida Bar membership portal to the ABA bookstore. This discount code gives you a 15% discount on any ABA bookstore purchase. Be sure and put it on your order form. Also, if you belong to the Law Practice Management section of the ABA, you'll get another discount. So the cost of these materials can drop by as much as 30%. Building your personal law practice management library. Every lawyer, and especially owners of law firms, should have a collection of law practice management reference books. You can't escape not having these. Don't waste your time on reinventing the wheel. Save time and money by having at your fingertips the knowledge of law office management best practices from nationally recognized experts. So building your personal law practice management library, most of the best law practice management resources available are located in the ABA bookstore. However, less than 2 linear feet of shelf space and a modicum of computer storage space will hold what you need to start and manage your law firm. A good starter collection of law practice management reference books. So the following slides I'm going to go over and highlight some of these books and CDs. LOMAS recommends that you look at these reference materials and decide which ones should go in your startup toolbox. The first one is How to Start and Build a Law Practice by Jay Foonberg. This is the 5th edition. It covers starting and building the law practice from soup to nuts, and it is a good complement to this DVD. This book is written for a national audience, but it's still the best handbook that the LOMAS PMAs have come across. Next, as I've pointed out to you previously, is Creating a Business Plan. This is a great little book. It's less than $25 at full price, so with the discount it's very inexpensive. And this will walk you through your needs of creating a business plan. However, if you have more dollars in your budget, this tool from the ABA, Automating Your Business Plan, is a piece of software. At full price, it's about $190 before the discount. So if you have this in your budget, this is a great tool for automating your business plan and keeping it up to date. Results-Oriented Financial Management is a step-by-step guide to not only law firm profitability, but law firm productivity. It includes financial reporting, billing software, internal controls, the purpose of keeping time, charts of accounts, and just much, much more. It's how to manage your accounts receivables and work in process. And if you're not comfortable with the financial management function in your law practice, this is a must-have. The LOMAS Practice Management Advisors, like all the books in the Lawyer's Guide series in the ABA bookstore, but we particularly like the Lawyer's Guide to Marketing Your Practice. This is a great handbook. LOMAS has some CLE DVDs on starting your marketing effort. You may even hire a marketing coach, but nonetheless, you need to familiarize yourself with the marketing discipline within a law practice, and this is a great handbook. Next, in the Lawyer's Guide series, is the Lawyer's Guide to Records Management and Retention. This particular book was written in conjunction with executives with the American Records Management Association. The American Records Management Association, or ARMA, has a legal industry SIG, or special industry group, within the organization, as well as medical and other industries. The ABA and ARMA got together and developed this guide. It includes a CD that has lots and lots of samples that you can use in your startup law practice, retention policies, and forms, housekeeping forms for records management. And it does cover going paperless. Compensation Plans for Law Firms is by James Cotterman of Altman & Weil, and he is considered one of the top experts in compensation systems for law firms. This is a great book. It comes with a CD, and it covers how to develop performance systems and what are the compensation systems, what are the factors, and has lots of forms for you to develop a plan that will fit your new law firm. Through the Client's Eyes is a book that not only covers client relations but also marketing, and it's a great way to put yourself in the shoes of your clients. Was written, has many contributing authors, and it's a very low-cost book, but it looks at client surveys and client interviews and tells you what do clients expect of their lawyers. LOMAS is often asked for employment agreements for lawyers and of counsel agreements for lawyers, and although we do have those sample forms, many lawyers are still confused about what is the of counsel agreement. The Ethics Department of the Florida Bar has a collection of informational packets. One of them is for of counsels, and it collects all the ethics opinions. It's a compilation of all the ethics opinions that apply to the of counsel arrangement in Florida. Nonetheless, this is a wonderful book to augment that informational packet. Also comes with a CD with many, many sample forms. The book contains lots and lots of example situations on managing the of counsel arrangement, what does it mean to each side, how to use it for transitioning senior lawyers, how to use it for transitioning laterals. It's a great handbook. Although you're watching a DVD today on how to start up and manage your law practice, this is a great handbook on career alternatives for lawyers. LOMAS practice management advisors often get telephone calls from lawyers who are involved in more than one line of business. They not only have a law practice, they may have another business, and sometimes they find themselves segueing away from their law practice into this other line of business. Sometimes lawyers just want to know what else is out there because the law practice is not enough. This is a great handbook, Non-Legal Careers for Lawyers, and it's a good read, and it's kept up to date by the ABA. Another, and what else to do with your legal career, the Legal Career Guide. We have gone through this book and critiqued it, and we find it also an excellent handbook to discuss career alternatives and building your legal career. And finally, Ethics Basics for Lawyers. This is not from the Law Practice Management section, but in fact is from the Business Law section of the ABA, and this covers the ethical pitfalls. William Frivogel is considered a national expert on conflicts of interest and business ethics for lawyers, and this is a must-have book on the ethical aspects of law firm administration, the ethical aspects of conflict of interest checking systems, client status reporting for lawyers, and much, much more. I'm going to end this DVD with asking you to please look before you leap. LOMAS practice management advisors say this at least once per day. If you have to contact LOMAS 50 times while you are starting up your new law practice, then call us 50 times. This is our job. Call us as often as you need to, because LOMAS and everyone at the Florida Bar does not want to see you in your name as the subject of a lawyer regulation grievance file. Look before you leap. Managing a law firm is hard work, but there are resources and dedicated people at the Florida Bar to help you properly establish and manage your own law practice.
For more information, visit the Florida Bar's LOMAS website at www.floridabar.org/LOMAS.